Hello and welcome to the latest episode of the Real Estate Rundown. My name's Andrew Jones and I'm a partner in the commercial real estate team here at Right Hassel. I'm joined today by a Real Estate Rundown regular, Claire Waring. Welcome back, Claire.
Thank you.
Claire is our leading development lawyer and today we're going to be talking about overage. So the first question, Claire, really is, what is overage?
So overage is a mechanism by which a selling landowner can benefit from any uplift in value realised if certain events or situations arise in the future once they've sold their land.
What sort of events are we talking about?
Well, there are different types of overage. So examples include planning overage. So that could be where, for example, a farmer sells land to a developer and it's sold at agricultural use value, which would be its existing value at that time. And then the developer subsequently achieves planning permission for development on it. In that situation, you would have overage, which would entitle the landowner, the farmer, to a percentage share in the uplift in value, which is attributable to the grant of that planning permission, because the land is then worth a lot more than it was at the point of sale.
Right. So those just based on the uplift in value at that point in time.
Generally on a percentage of the increase in market value, or sometimes you have overage which is a fixed sum. Right. So that you don't actually have to do a calculation at the time. But sometimes when you're selling on that basis, it can be difficult to ascertain what that fixed fee, what that fixed sum should be. So that's why the calculation based on the increase in market value is quite a popular concept, quite a popular mechanism. Other examples of overage are if development land is sold at the benefit of planning permission, but the developer may go away and obtain a more valuable planning permission within a certain time frame after completion. And if they achieve that better planning permission, which, for example, might give them more units in number on the site, or a different mix of units which are more valuable and allows them to achieve a greater revenue than they would otherwise have had, then the landowner can be entitled to a share of that increase in value. Also, you might have what's called sales or revenue overage, where the developer's price that they've paid is based on them achieving X in sales revenue for the plots.
Okay.
And
is that worked out on a square foot basis, or is that how generally do you calculate that?
It's generally worked out on, it can either be on a plot by plot basis. So as you're going through, you have a particular value assigned to each plot.
So it might be £200,000, but
for plot 12 is 250,000 whatever. But actually, if you achieve greater than that for plot 12, then you pay a proportion of that to the landowner. Or you might do on an aggregate basis. So if the whole of the site achieves, greater than 4 million or whatever, then the landowner is entitled to a proportion of the excess revenue that's been achieved.
So what's in it for the developer? Why would I, as a developer, want to have to pay more if I have a windfall?
Well, that's one way of looking at it, but another way of looking at it is that if a landowner is undecided about whether to sell or is unconvinced about the price, they may not sell at all. But if they're
worried about embarrassing themselves.
Yeah, so if they've got the security that actually, if the developer has a better day than is currently anticipated, they have a mechanism in which they can share in that uplift, in that better payday, then that might encourage them to do the deal with the developer and sell the land to them. And from the developer's point of view, there's not a great deal of risk because they're paying a lower initial price and they don't have to pay any overage or any uplift to the landowner unless they achieve that better value.
Yeah. How long does an overage tend to last? Is it forever or is it time limited?
It's time limited, but what that time limit is can vary hugely. So if it's if it's development land that's sold with the benefit of planning permission, then it will fall away once the developer completes the site with the benefit of the original planning permission, implementing the original planning permission, because then you know the overage is not then going
one bite of the cherry.
Yeah, exactly. But for planning overage, where bare development land is sold at existing use value, can go on for 25, 30, 35 years.
Particularly if there's no prospect, presumably, of planning at the point that the land's sold.
Exactly. So the more distant the development prospects, the longer the overage period would be. And on sales overage, sales or revenue overage, where it's based on the revenue that the developer achieves for particular plot sales, you would want to draw a line under that after, 5, 6, 7 years to give the developer a chance to build out. But then you want to draw a line and say, well, actually, if you haven't sold any by that point, you have an assumed valuation, assume you have sold them, and you pay out the overage then. Otherwise, it could just drag on and on and on.
I can see some cash flow challenges potentially for developers, depending on when the trigger point is for the value or when the payment's made. So how do payments terms work with these overage provisions?
So from a developer's point of view, on planning overage, you wouldn't want any overage to become payable at least until the judicial review period has expired and you know that your planning permission is safe.
Yep.
But also from a developer's point of view, you would want the payment date to be later. So not until implementation, because you might have a planning permission, but you might never actually do anything to realise that value because you might not implement it.
And that could be a real trap for developers if the payment date is wrong. That's a real risk, isn't it?
Yes, if it's on the date of grant, then or when the judicial review period has expired, because at that point you've still not crystallised the position by actually implementing. So from a developer's point of view, you would want it to be on the earlier of implementation or them selling on the site with the benefit of that planning permission, because that crystallises the value at that point.
Yeah, and particularly if you're selling it on, that's when you've got some money to pay the original landowner. Otherwise you could have a right cash flow problem.
I mean, if it is on implementation, then yes, the developer is effectively paying out more money before it's achieved any return on the plot sales.
So something to think about when you're thinking about cash flowing these
just
sites.
Something that needs to be put into the viability.
Yeah, absolutely. How are overage terms usually documented?
Usually by a separate overage deed. You used to see them more often in transfers.
Yes.
But the difficulty is that tends to clutter up the register a bit, and nobody particularly wants to see the detail of them. So now they tend to be done in separate overage deeds, which are then referred to on the register.
And that obligation to pay the original landowner, does that just run with whoever owns the land? So if you sold it on before you got planning permission, does it automatically run the burden?
The burden of it, from the landowner's point of view, you want to make sure that the burden runs with it. So what you need to do is ensure in the deed that it's clear that the overage obligations are supposed to bind the developer's successors in title, and also protect it by putting in place a restriction on title and deed of covenant mechanism, which means that if the developer sells on other than things which are permitted disposals like plot sales,
or infrastructure maybe,
agreements, easements, electricity substation transfers, all of those are generally termed permitted disposals, and that won't require the disponee to enter into a deed of covenant to be bound by the overage terms. But other than that, if the developer is selling the whole or part onto another developer in, say, a parcel sale, or just shifting the entire site onto another developer, they should be required to enter into a deed of covenant with the beneficiary of the overage, so that they are bound by the terms of that overage and they're not sidestepped.
Because it doesn't automatically run that obligation, because it's a positive obligation rather than a restrictive covenant. Yeah, I guess that can trip people up if they don't put the right mechanisms in place.
Yeah, I mean, if an overage agreement can be beautifully drafted, but if it's not protected properly, then it's worthless. So you have to think about how to protect the overage agreements. And in my experience, the most common way of protecting the overage agreement is by a title restriction and a deed of covenant mechanism. There are other ways of doing it, but they tend to be more problematic. For example, you can have a legal charge over the site that protects the overage.
Well, I was going to ask you, Claire, if once the overage is triggered, how do I secure payment from you as the developer if I'm the original landowner? Is there a mechanism to make sure, well, basically, if you don't pay me, can I take the land back, for example?
You would only be able to take the land back if you had a legal charge which you were able to enforce over the land. And they're quite unusual because having a first ranking legal charge over the development site obviously curtails what the developer can do with that site. And it may need to raise development finance in order to build it out. And you want them to be able to do that because you want them to build out because you want your overage. Similarly, you can protect overage by restrictive covenants, but in order for that to work, the beneficiary has to have some retained land that can actually take the benefit of that restrictive covenant, and it has to serve another purpose other than just being a mechanism to secure the overage. It has to touch and concern the land in the way that restrictive covenants do normally. So generally, it is the restriction and deed of covenant mechanism. And that will be the security for the payment of the overage. If the overage wasn't paid, then you would have to enforce in the normal way, and it would be a breach of contract. Be a breach of contract claim.
Just going back to the trigger on overage payments, I think we've touched on this a little bit, but there seems to be various stages. And would it be normal to have the payment only due like when you sold the site, either you sell the whole site onto another developer, for example, or when you start selling those units? Is that quite a normal way of getting payment?
It is. You either implement the planning permission yourself, which triggers the overage, or if you sell it on with the benefit of that planning permission, because then obviously you get a capital receipt from the incoming developer out of which you can satisfy the overage.
It sounds quite a complicated area. Are there any risks?
Lots and lots of risks. And acting for the landowner, one of the biggest risks is to ensure that it's properly protected.
We've touched on that with the restriction. That seems to be quite a very important point, really.
Yeah, because irrespective of how well the deed itself is actually done, if it's not properly protected, it's worthless. So from the landowner's point of view, that's hugely important. But I think it's one of the areas that gives rise to probably the greatest amount of litigation.
Yes. Well, that's really useful, Claire. Thanks for that. Is there anything else that we need to think of when we're dealing with overage? I mean, there seems to be a lot to think about there, but I think we've covered a lot in the last few minutes. But
I think that's probably enough for the sort of high-level analysis of it.
I think for me, the takeaway is take proper advice. I mean, presumably it's something that the lawyers, the solicitors would have to work often hand in hand with the surveyors and the valuers, particularly where there's a market value mechanism. I
mean, the valuers wouldn't necessarily be involved in drafting up the overage deed when the trigger actually happens, and you have to work out what the market value is. If that's the base on which your overage has been drawn, then yes, the valuers would be involved at that point, because they would need to work out your base value and your enhanced value and stuff. So the valuers are involved at that stage.
And potentially what deductions you can take off that number. Complex area, so I think take advice is the advice.
Indeed.
Thanks, Claire. That's great.
Thank you very much.